Yep, I can now, yes. That's me.
Okay, you're here today for what's called your settlement conferences. You have one case with the City of Grand Rapids. We have City Attorney Angelo Ross here on that case. Your other case involves a charge issued by the state of Michigan, and we have Mr. Firestein from the prosecutor's office on that case. So you need to, I'm going to let the three of you discuss the case, see what, if any, kind of offer is available on this one, and then we'll go from there. Okay?
Sure, Judge. Did you receive my objections?
I don't know what they received. I think maybe what's easiest at this point is maybe to put the three of you into a breakout room, and then you can quickly discuss it. I will tell you, there's probably about 30 other cases, people involved this morning, so we're on a really tight schedule. So it's not an opportunity to hear motions or discuss motions. That would have to be noticed separately. But it's just a conference. It's a casual conference. So I'm going to put you in that breakout room conference. You can talk to them, and then we can see where this is going to go after you have that conference. Okay? So I'd ask you to join the room when prompted. All right, sir?
Okay.
All right. Sounds good. Thank you.
Good morning. I was told Mr. O'Hara was going to be handling my case.
Yes, so I'm an intern, and I'm handling it for him for today. Okay, but he is the APA you'll normally deal with.
Okay, and you are allowed to speak for him?
Yep. I'm a law student. Yep, it's part of the program.
So you act in the name of the prosecutor?
Yes, for today I do. Yep.
Okay, what is your offer, Miles?
So I have as charged with no jail recommendation and continue if at all possible.
Okay, offer would be that if you plead to that, then I would dismiss my fail to obey.
Okay, how do you know that?
There's a note in my files.
So you don't have any personal first-hand knowledge of that?
That would be what the order is. So the offer is if you plead to the continue and the fail to obey would be dismissed. So that's the offer. If you want to plead to that, you can do that today, or we can set it for a jury trial or a non-jury trial.
Good. Let's go to trial. Let's set it for a jury trial.
Okay. Sounds good. Just go leave the breakout room, and then we'll go to the judge and let him know. Okay.
I don't know how to do that.
Okay, it should say leave room or leave breakout room.
Yeah, it should be at the bottom hand corner of the screen typically.
Okay, leave.
Yeah. I'm not sure. Did you push?
Yeah, looks like you're still in here, Mr. Hardy.
I'm hitting. Okay, there we go.
All right, Mr. Hardy, thanks for coming back. We're just going to wait for the attorneys to show up, and then we'll go on the record, okay?
Sure.
Okay, I'll recall these cases here again. The cases we have are case number 20, City of Grand Rapids, case number 9, People of the State of Michigan versus, and you had a chance to meet with both the city attorney and assistant prosecutor. Is that correct?
Yes, it wasn't very meaningful or useful, but I did talk to them. Yes.
Okay. All right. Well, let me ask this question: was there any offer that has been extended? I'll ask you, Ms. Ross, first on the city case.
Yes, Your Honor. I have offered to dismiss my case if there is a plea in the state case.
Okay. And what would be the offer on the state case then, Mr. Firestein?
Yes, Your Honor. It was as charged with a no jail recommendation. Continue for the victim.
Okay, and let me ask you, make that note of the file. You understand these offers that have been extended, correct?
I heard them, yes.
Okay. And you comprehend what you're being offered, correct?
Yes, what I don't comprehend is what this settlement conference is about. A settlement conference generally proceeds with both sides presenting a position, and a discussion goes forward from there. This was just a plea offer conference.
Well, again, I don't know what was discussed, but certainly if you have a position as to why, you feel like you've got a strong defense and it should be considered as part of an offer, yeah, you can relay that information. That's fine.
I submitted objections to the court this morning, and those should be taken into consideration.
Okay.
Your Honor, we had the settlement conference. He didn't want to relay his position. He has some written, I'm not sure what, but they weren't presented. So we did extend the offers. They were fair offers, and that's what they are. He has chosen to set it for a jury trial.
Okay. All right. Well, here's what we'll do. At this point in time, again, I don't know what the basis of the objections are. If it's something you'd like the court to rule on as a matter of law, then you would need to file a motion and provide notice of the hearing to both the prosecutor's office and the city attorney's office. And then we'd schedule it for a hearing accordingly.
Here's the thing, Judge. We're not really posed in a position to go to trial here because I have not yet been arraigned.
Okay, sir, you have been arraigned. This court arraigned
objection. Do I have the right? Objection, Judge.
Listen, I'm not here to quarrel with you about whether or not you believe your rights have been somehow infringed. If that's the case, you may file a motion and you may seek to dismiss the case accordingly. But at this point in time, this court believes that all your procedural rights have been provided thus far, and we're going to proceed with the case accordingly. So the path of your case now is to set it for a trial either by judge or jury. In the meanwhile, you certainly have every right to file any type of motion that you would like to file, and we can go from there, okay? And that's the way it's going to go. I'm not going to spend a lot of time quarreling with you about whether or not your rights have been properly extended or provided.
There's a difference between quarreling and hearing a person.
All right, sir. You made a statement about the fact that you did not believe that you have been properly arraigned. If that is the case, I need you to bring some type of motion hearing to the court as to why you believe that's the case, and then we'll go from there. But I'm not going to rule on that here today, is what I'm trying to explain. Okay? Do you understand that?
No.
Okay. Well, I'm not sure if you would like to have an attorney help you understand. If you cannot afford one, the court would be happy to appoint one for you, where the attorney should be able to, again, explain to you some of the procedure and your rights in more detail. Would you like the court to appoint counsel for you?
No, thank you.
I know that was offered to you on a previous occasion. You declined.
It was not offered. It was not offered to me on a previous occasion, but I don't care.
I believe the record would suggest otherwise, but we can always take a look at the record and verify whether or not that's the case.
Great. Would you please send me the record?
I'm offering you again today that right to have to be represented by an attorney. If you cannot afford one, the court would appoint one. You're telling me today you do not want to have counsel appointed for you. Is that correct, sir?
Great. No, what I was trying to say was, will you please send me the record?
Well, you can request a record. You can come in and obtain a copy of, you can contact the recorder and get a recording of the record. That's the way it goes, a transcript of that record.
Do I have a right to obtain that?
Okay. Yes, you do, sir.
Well, I'd like to exercise that right. I'd like to exercise that right now.
Okay. I've explained to you that process. You'll have to contact the court recorder and request a copy. And there's a form that you have to complete to make that request, to formalize that request. I believe it's a form, correct?
You can even just write an email to me.
Okay, yeah. If you want to even email it to, there is a fee associated with that. But I guess we could accept even an email request.
All right, I'm not in a position to cover any fees for transcripts right now. Will you waive that?
Okay. Well, you would have to fill an application as to why you qualify for a waiver. There is a form there. There are some grounds that would entitle you to have that waived, and you have to, again, notify the court as to what the basis or grounds would be that would support that request.
Great. Will you please send me that waiver?
No, well, you can contact the court and we can get you a copy of that. Okay?
Well, seeing as how I have
All right,
the recorder's
Sir,
attention right now, I'm asking for the waiver.
Okay, I understand that, but I don't have a copy of it here to send to you right this moment, sir. Do you understand that?
I'm asking you to ask the clerk or the reporter who's right next to you to send it to me.
All right, I don't know. Do we have any kind of copy here so we can? Do you want me to complete it for you too, Mister? I mean, the reality is
That would be amazing,
you have
Judge.
some responsibility to get this done on your own behalf.
That would be
And
amazing.
you taking action beyond making demands of the court. You have to contact the clerk's office. The clerk's office has that information.
I would really appreciate it. I would really.
try to accommodate you, but we're done right
No,
now.
you're just talking
We've got
over me,
the
Judge.
information.
You're just talking
Let
over me,
ask you
Judge.
this question.
I would
Let me
really
ask you this
appreciate it
question,
if you would fill it out for me.
Sir.
That would be great.
Sir, let me ask you this question. Would you like me to schedule at this point? There's a few options. The case is fairly new. We can set it for another pretrial conference.
Fairly new. The objection. This case is dragging on forever.
Okay. Well, you were arraigned on June 11th. Given the backlog through the pandemic, this is less than 2 months.
Objection. I was not arraigned on. I was not arraigned on June 11th.
As quickly as possible. I will tell you that there are some cases that are in line in front of you for jury selection that we were not able to pick a jury during the pandemic, and so we'll try to put it in process in line as quick as we can.
Do I have the right to a fair and meaningful hearing? Do I have the right to a fair and meaningful hearing?
We are all set.
Do I have the right to a fair and meaningful hearing?
I'm not. I can't give you legal advice at this point in time.
Do I have the right to a fair and meaningful hearing?
All right, sir. You may contact an attorney to understand what your legal rights are.
Do I have the right to a fair and meaningful hearing? Do I have the right to finish an English sentence without being talked over?
Sir, I am listening to you.
You have not listened to me at all, Judge. You've talked over everything I've said. That's interference.
All right, sir. We are all set with
Do I have the right to be heard? Do I have the right to be heard?
You have been heard. I've heard you on numerous occasions. I've answered your questions, and I don't have all morning.
Objection. I have been filibustered. That's different than being heard.
All right, sir. We are all set. If you have anything further, you may contact the court to set a hearing date if you feel like your rights have been infringed. Thank you very
Objection.
much for your time.
What is the next? What are you claiming is the next step in this process?
We're scheduling your matter for a jury selection, and we'll provide you notice as quickly as we can.
Earlier, you told me that I could set it for motions.
You may do so in the meanwhile. You can schedule a motion hearing at any point in time.
Well, seeing as how
Again,
we're
sir,
addressing the issue.
You're asking the court for legal advice as to the procedure, and frankly, that's not this court's position.
You're
It's not my
conflating.
role here.
You're conflating
My
legal
role-
advice with procedural advice. I'm asking about procedure, not asking for legal advice. I don't care for legal advice.
Okay, that's what an attorney can help you understand the procedure as well. That's something counsel can help you with if you have questions about it. That's why I offered you counsel, and you declined that.
All right. Are we addressing the issue of scheduling now?
We will schedule the matter. Would you like to have another pretrial conference?
I'd like to have a motions conference.
Okay, you need to schedule a motion hearing then through the clerk's office.
If
There's a
we're
procedure.
addressing the issue of scheduling now, will you please set it for motions?
Sir, I can't schedule it for you. You have to schedule that on your own. You can contact the clerk's office. It has to be in writing. The other parties have to be served. Now, I'm kind of explaining to you the legal procedure. If you have questions about it, I encourage you to contact an attorney. If you cannot hire one, I would appoint one for you to explain that process to you in more detail. Do you understand that?
No.
All right.
I don't have any questions that are of that nature. I just want to know why you won't set it for motions.
I will set it when you file a motion hearing. That's when it's set. You
I
have
have-
every right to it. You have to file that.
I have filed a motion with the court. The court's response should be to set a motions hearing.
Sir, you need to schedule a hearing. You need to schedule a hearing. And you need to do that by providing notice to the parties as to when the hearing is scheduled. So you contact the clerk's office. They'll provide you a date, and we cannot give you legal advice as to how to do that. If you have questions about the procedure, again, there's a legal assistance center can also answer some of those procedural questions. You understand?
That isn't the issue, Judge.
Okay. Well, I'm not sure how else to explain it to you, but I simply don't have time for this hearing.
That's great. If you don't have time to prosecute me, that's music to my ears. Dismiss the case. That would be just fine.
All right. Sir, we're all set. I'm going to conclude this pretrial at this time.
Judge, who will be responding? Judge, who will be responding to my objections that I sent to court today? Will you respond to those?
Well, I rule on them, sir. I don't necessarily respond to them. The city attorney and the prosecuting attorney have a right to respond. That's why they have to be provided notice of the hearing. That's what I'm trying to explain to you, and that's why you have to schedule it for a hearing. And there's a time limit. You got to give it at least, I think, 9 days. Schedule it out, and you got to provide them notice in advance. There's
All right.
a procedure for it. It's explained in the Michigan court rules. If you want to look at them, how to schedule a motion hearing, you can access that information, and you can make that determination about how to do it and how to provide notice. You can contact the court to get the hearing date, but it's up to you to schedule or to send out the documents, provide notice of the information and the issues that you would like the court to rule on. You understand?
I have sent the information that I'd like the court to rule on. When will the court rule on it?
The
All right,
court
sir.
does not rule until you've properly filed a motion. I don't know what your objection is, but unless I get a motion, I'm not responding. So once you properly file a motion and notice myself in the prosecutor's office, you won't get a response. So once you motion it, we will respond and then have a hearing. At the same time, you're also going to be set a jury pick date because we will be going to trial since you don't like these offers. So once you properly do that, we'll answer them.
How can we go to trial when I haven't been arraigned, Angela?
Okay.
You
All right.
have to.
All right, sir. Again, I think we've covered this ground. I appreciate Ms. Ross explaining it from her perspective, and I think that's what I've tried to explain to you. I don't know how else I can say it any more simply.
Well, at the last appearance, you told me I was more than welcome to object to any procedural matters that I felt inclined to object to. I've done that, and now I'd like to know about the response.
Okay, well, I don't have that objection in front of me at this point in time, so I'm not sure. Here's the thing, sir. I'm telling you right now, I'm not going to rule on your objection until we have a motion hearing. So that's what we're going to do. You contact the court to get the hearing date, and then you notice it up pursuant to the court rule. That's the procedure moving forward. It's been explained to you several times. I'm not sure how to explain it in any more detail, any more clearly. So we are all set. We're going to remove you from the hearing at this point in time and move on to the next matter. Thank you very much for your time, sir.
All right, I object to this hearing as an appealable issue.